Good day, everyone. We will get started here in just a few moments. Good day, everyone. All right. Thank you to everyone for joining today's Ask Me Anything about cannabis legalization in New York. My name is Jeffrey Hoffman. I'm an attorney here in New York, specifically in New York City. I have a legal practice that focuses entirely on cannabis and helping individuals get their licenses to become licensed cannabis businesses here in New York State. I got a number of questions from folks, both via LinkedIn and via email, and even a few via phone calls. So I think we will dig into some of those questions now. Um, and please add your questions to the comments. I will try to go back and forth in between the comments I got questions I got previously and the questions that are coming in through the comments. I'm quite certain we will not be able to get to all of them. I have quite a few, but we will do our best in the time that we have. I do want to make one disclaimer very quickly. I am indeed an attorney, but I am not your attorney, at least not yet. Though I will note that I did notice that a few of my clients have snuck in to the attendee list. So for you folks, I am still your attorney. Don't worry. But for the rest of you, I am not your attorney. And this presentation is not legal advice. If you have questions about cannabis legalization that are specific to you or your business, I certainly encourage you to get proper legal advice from the counsel of your choosing. So, with no further ado, let's get into some of the questions that we received. All right, first of all, if I apply for the conditional dispensary license as a social and economic equity applicant, can I also apply for a future license as a micro business? Um, Two very popular ideas that are going on right now: the conditional dispensary license, which the Cannabis Control Board proposed recently, which is currently in its public comment period. It does appear from the draft regulations that the CCB prepared for that conditional retail dispensary license that, in fact, if you get that conditional dispensary license, you will not be able to apply for any other licenses. This was a question I got early, so to give you some very specific reference for that, if you look in section 116.7 C11 underneath the proposed regulations from the Cannabis Control Board, they make it very clear that anyone that holds this adult use conditional license cannot hold basically any other license available under the cannabis law, and that would include the micro business law. Moving over to a question that we just got through the comments. In New York, do you need a conviction or can you only be arrested for a cannabis offense? And I assume that that question is related to what we were just mentioning, the conditional retail dispensary license. One of the requirements of that conditional retail dispensary license that we see in the regulations, the proposed regulations from the Cannabis Control Board, is that a conviction is required. And our belief at this point is that is indeed what will be the case. An arrest will not will not suffice. You will indeed need to have had a conviction for a cannabis related offense in New York State prior to March 31st, 2021, in order to be eligible for that conditional retail dispensary license. This issue has come up a number of times with folks that I've spoken with about this. there is something that happened to many folks that had a very low level cannabis offense in New York known as an adjournment in contemplation of a dismissal. Um, I have seen that question has gone to the Cannabis Control Board. Perhaps we'll see something further along those lines when they release additional information after the comment period for this conditional retail dispensary license. But at least as far as it stands right now, you will indeed need to have been convicted of the cannabis offense. An arrest will not be sufficient. All right, moving back over to a question that we got via the before the session started. It's related to on-site consumption lounges, and the question is: will on-site consumption lounges be allowed to sell cannabis directly to patrons, or will they be required to be co-located with dispensaries? Now, I think as folks have seen, the Cannabis Control Board does seem to have fairly wide latitude as far as the things that they are proposing via regulation and that other things that we may see in the future. But it does seem apparent from the cannabis law as was enacted by the legislature that it seems relatively clear that indeed on-site consumption lounges will be able to sell to patrons directly. The way I've kind of phrased it is that they will be able to hold their own inventory and directly sell that to their customers. If you look, just one particular place that I find that I think that supports that in Section 71 of the cannabis law, which actually talks about the distributors, but it says very specifically that distributors will be able to distribute to duly licensed retail dispensaries and on-site consumption sites. So based on that reading, it seems fairly clear to me that if a distributor is going to be able to distribute product to an on-site consumption lounge, that indeed the on-site consumption lounge will then be able to have their own inventory and sell that inventory directly to patrons of the on-site consumption lounge. Let's go to another. There were a couple of questions that were related to the consumption lounge, so I think we will go ahead and let's address those. Another question related to the consumption lounge was, will there be similar locational restrictions on this category, that is the on-site consumption category of license, as there is on dispensaries, the normal retail dispensaries? And the location restriction that I imagine is being referred to here in particular is the 500-foot rule and 200-foot rule. That is that a retail dispensary cannot be within 500 feet of a school or other various educational facilities and can't be within 200 feet of a house of worship. And that same restriction does indeed apply to on-site consumption lounges. So, and that is in Section 77 of the cannabis law, if you're interested in looking at it yourself. But it does seem very clear that distance requirement, that locational requirement, as was asked in the question, will also be a requirement for the on-site consumption lounges. There was one additional interesting question we got in that batch about on-site consumption lounges, and that was, am I correct that the only other license category permitted to operate an on-site consumption lounge would be a micro business license? Now, again, to what I said previously, the Cannabis Control Board clearly has wide latitude as to the types of things that they are going to implement. It seems, unless it is in direct contradiction to the cannabis law, that the Cannabis Control Board is going to have pretty wide latitude as far as the regulations that they propose and perhaps eventually implement. It does seem that the question of whether or not the on-site consumption could be operated by a micro business is probably not. Now, in the law, in Section 73 about the micro business, it does not specifically mention on-site consumption as an activity that the micro business can engage in. The specific language that it uses is, a micro business license shall authorize the limited cultivation, processing, distribution, delivery, and dispensing of their own adult use cannabis. Now, is there perhaps room under the word dispensing for an on site consumption lounge to be included there? Certainly possible, although one would think if the legislature intended for the microbusiness to also include on site consumption, it would have included that in the list there. I will simply note that there is a very broad clause in the section about the microbusiness license where it says that the size and scope of the license is going to be determined in regulation by the board. So it's entirely possible that the Cannabis Control Board will further the scope of the microbusiness license and allow them to operate some form of on site consumption. I do believe, however, if they do allow that, it would again only be the micro business's own cannabis. That is cannabis which that micro business grew, processed, etc. That would be allowed to be sold at that on-site location. Just again, at this time, it does not appear that the micro business would be allowed to do that, but it clearly is within the right of the Cannabis Control Board to expand that scope and perhaps allow micro businesses to indeed participate in that. All right. We have a question about the DASNY fund that is being made available. Just a reminder, DASNY is the dormitory authority of the state of New York. They basically built all of the dormitories at all of the colleges and universities across the state, and in fact, are responsible for building much of the real estate that the state has. DASNY is going to be responsible for dealing with the Social and Economic Equity Fund, which the state is going to be spooling up. The question is whether or not the conditional dispensary licensees are going to be required to use the retail space that DASNY is going to create using the funds from the Social and Economic Equity Fund, and whether or not all DASNY fund applicants must be these conditional applicants. So to answer the first question first, it does appear in the regulation for the conditional retail license, it does say that any of the licensees under that regulation must enter into any agreement that the fund presents to them. So my reading of that means that yes, indeed, if DASNY wants to require a conditional licensee to use their retail facilities, that yes, indeed, that is a requirement and will be something that the conditional licensees for those conditional retail dispensaries must do. The other question is, will all DASNY fund applicants have to be this conditional dispensary license? That is not entirely clear yet. The way I have read it is that that will not necessarily be the case. I think that it is an open question at this point whether or not there will be sufficient folks that can qualify under the fairly strict requirements that the conditional retail dispensary license will have. That is both having been convicted of a cannabis offense prior to the enactment of the cannabis law here in the state of New York, and being able to demonstrate that the applicant was a 10% owner of a business which was profitable for 2 years. It does seem that it would be in DASNY's interest to make these facilities available to all social and economic equity applicants that get retail dispensary licenses. But it will be an open question how many actual applicants there are for the conditional retail dispensary license, and whether or not that would fill out all of the inventory. I do think that is the group that will get the priority for the DASNY retail dispensary locations. But if they're not able to fill that amongst the conditional licensees, I absolutely would imagine that DASNY would go on and make those locations available to normal social and economic equity applicants for retail dispensary licenses that had not previously been convicted of a cannabis offense. All right, going back to some of the questions that we got before the program. Someone asked, how many cannabis licenses can I get? can I get a grow license and a retail license? So the immediate answer to that is no, you cannot get both a grow license and a retail license. And I think a very good way to look at kind of this tree diagram of who can get how many licenses is to think of it as an upstream license and a downstream license. For me, the upstream licenses are the cultivation license, the processor license, and the distributor license, everything that happens before you get to retail. Now, within those upstream licenses, you will be able to get both the license you're applying for and one additional license or perhaps two additional licenses downstream from you. So, for example, if you get a cultivation license, you will also be able to get one processing license and one distributor license, but those two other licenses will be only of the cannabis that you have cultivated. And similarly, if you are a processor, you will be able to get an additional distributor license. Downstream, and there will be no crossover between upstream and downstream. If you get one of the upstream licenses, you will not be able to get one of the downstream licenses, those being um, delivery, the retail dispensaries, and the on site consumption. Now, you will be able to, within a retail license framework, be able to have three locations. It does appear that those will be three separate licenses for three separate retail dispensary locations. But that is the only place where you'll be able to see multiple licenses within one of these license types. Now, the micro business license, which we mentioned previously, will be able to be fully integrated, vertically integrated. That means the micro business will be able to grow, uh, process, distribute, and sell at retail their own cannabis. So any cannabis that a micro business grew, they will also be able to engage in those other activities under that single license. And just for sake of nomenclature, I have been calling that what we see upstream, where a cultivator can also get a processor and a distributor license, I've been calling that semi-verticalization. So I just think it's a good way to think about it: upstream versus downstream, and semi-verticalization versus full verticalization. Um, there was a question on the comments. The comment period ends May 31st for the New York conditional license. That is the retail dispensary license, the conditional one that we've spoken about before. Do I see a major change in specifications needed to obtain a conditional license? So I think it's going to be a toss up between how quickly does the Cannabis Control Board want to move on getting this license out into the marketplace versus what types of comments they get about the license. So, in order to move very quickly, they would simply have to say, "We got all of your comments. The 60-day comment period was great. We're not going to make any changes, and we're just going to proceed with the regulations as they were. Off we go." Very similarly to what we saw with the conditional cultivator license, which was created by the legislature, so no comment period was necessary there. I think, as folks saw, the legislature passed that, and the Cannabis Control Board and the OCM had the application for that up very quickly, and in fact have already issued a number of conditional cultivation licenses. The conditional retail license, I think I mentioned before, has a bit of a controversy about the fact that many people that have been convicted of a cannabis offense may not be able to show that they were a 10% owner of a business which was profitable for 2 years. I think that is going to be one of the primary pieces of feedback that we get on that on that regulation. I do think there's probably some folks in the legacy cannabis market in New York that did not have a conviction on the record, who are probably not very happy that while they were basically the entire cannabis industry for the entire time it's existed prior to now in New York, that they are not being given the first bite at the apple on those licenses. So I do think it would make sense to see some revision as to the biz profit showing that you had a business that was profitable for 2 years requirement. I think there are some other ways that individuals could prove that they are capable of operating a business. I think ultimately that's what the show us that you were profitable for 2 years is trying to accomplish. I think there's other ways that could be accomplished, and I do think that that would be a very valuable modification to the specifications to the regulation that the CCB has proposed. And I think we'll just see at the end of these 60 days whether or not that's the case. If the CCB does want to modify the regulation as they proposed it currently, then we will have to go after they figure out what those modifications are, and that may take some time. We would then have to go through another 45-day period, which is known as a revised rulemaking period. So that will take quite a bit of time before we get those regulations fully promulgated and the application open. So it really comes down to, does the CCB want to move very quickly, or do they want to try to get the regulation better based on the feedback that they receive? All right, going back to some of the questions we received prior to starting. Can I smoke cannabis in parks in New York City? And can I smoke cannabis in my apartment? Very interesting questions. So in New York City, so just generally, parks cannot, you cannot, you can smoke cannabis anywhere you can smoke cigarettes. That is one piece of the cannabis law here in New York that is radically different from how it's been implemented in any other state that has legalized so far. In every other state that has legalized so far, while there are certainly people smoking cannabis in public, the way the law reads in just about every other state, I think pretty much in every other state, is that cannabis consumption is limited to your private home, private event spaces. Some of the states are trying to backfill on-site consumption, so obviously in those spaces, but generally the public consumption of cannabis is not allowed in any other state. Again, in New York, the law was written such that you can smoke cannabis anywhere you can smoke a cigarette. Now, here in New York City, you are not allowed to smoke cigarettes in parks, even though I do see people doing that fairly regularly. So just as far as it goes legally, since you cannot smoke cigarettes in parks in New York City, you also could not smoke cannabis in parks in New York City. As far as your apartment goes, the same rule applies as far as anywhere you can smoke cigarettes, you can smoke cannabis. So if you live in an apartment where you are allowed to smoke cigarettes, you would also be allowed to smoke cannabis. But if your apartment has a non-smoking rule, then of course, since you would not be allowed to smoke cigarettes, you will also not be allowed to smoke cannabis. All right. Next, let's go to another. We've got a couple minutes left here, so let's go to another question from the comments. Do we know how many social equity cultivation licenses will be available? At this time, we do not know how many of any type of license will be available. I will simply say that Tremaine Wright, the chair of the Cannabis Control Board, has said over and over again in every public event where I have seen her speak that unlike other states, some other states have a fixed cap of the number of licenses that can be issued, which obviously creates an artificial scarcity in the availability of licenses. Tremaine Wright has made it very clear that in New York, the law does not specify some arbitrary limit on the licenses, the number of licenses. The Cannabis Control Board does not have in mind an arbitrary limit on the number of cannabis licenses that will be issued. Their goal is to meet the needs of the marketplace and to accomplish the goals that the cannabis law has for social and economic equity. That is, social and economic equity applicants, there's a goal that they will receive 50% of the licenses. And I think the cannabis industry in New York is going to be incredibly large and robust. So I don't think that, again, that the board is thinking in terms of a set number of licenses. Rather, they're going to want to see how the market evolves, and they are going to issue however many licenses are necessary to meet the needs of the market. However much cannabis needs to be grown in the state, they're going to make sure that there are enough licenses out there to accommodate that need. All right, a few more questions, and then we're going to wrap up. Um, when advertising my licensed cannabis business in New York, would I be able to have a celebrity such as Snoop Dogg smoking my product? That's a great question. I really like that one. Um, the answer in New York is no. You will not be able to have someone smoking your product in the advertisement. I know I've seen cannabis advertising in other states where indeed there did appear to be consumption. I'm not an expert on every other state's advertising rules, but I have indeed seen that. New York has a very specific rule in the cannabis law that you are not allowed to depict consumption in your advertising. All right, we're going to do one more question, and then I think we're going to wrap up for today. As I do have to get to a client call at 5 o'clock, so do have a hard stop there. But let's do one more. Um, I've seen that in order to apply for a cannabis license, I will need a labor peace agreement. What is that? All right. So, a labor peace agreement, or as we are calling it, we lawyers love acronyms, so we're calling it an LPA. The labor peace agreement is an agreement that will be signed between the cannabis applicant and a labor union here in the state of New York. And having this labor peace agreement is an absolute requirement for you to be able to apply for and get a cannabis license. You will not be able to apply for and get a cannabis license in the state of New York if you do not have a labor peace agreement. Obviously, what that means is it gives the union, which you must have that agreement with, a fairly strong hand in their negotiations with what that union will want to see in your labor peace agreement. I have negotiated such agreements with unions here in New York and have actually executed them for some of my clients so that they're ready for their licenses. And basically, what you are seeing in these labor peace agreements is that the union is going to want a list of your employees and their contact information and effectively unfettered access to your employees so that they can pitch your employees about forming a union and joining the union in New York. And they're going to require you not to badmouth the union or in otherwise prevent the union from engaging in its activities with your employees in order to unionize them. Again, the union is going to have a very strong hand in their negotiating with you. You're not going to be able to apply and get a cannabis license without this labor peace agreement. The flip side is that the union is going to agree to not do a strike or have any type of work action against your organization. That is, as long as you meet your part of the requirement and allow them unfettered access to your employees and their ability to attempt to unionize your employees. All right, so I think that was a good number of questions that we were able to answer today. I got a large number of questions before the event and also a substantial number of questions here in the comments that we were not able to get to today. So I do think I'm probably going to make this a fairly regular occurrence on Wednesdays at 4:20. We'll just do an Ask Me Anything about cannabis every Wednesday at 4:20. So if you're interested in participating next week, go ahead and put it on your calendar. Definitely be checking out my LinkedIn feed so you can make sure that we're going to have that event. I will note that there were several of you that signed up for the event that are not currently a connection of mine. If you're not a connection of mine, by all means, reach out and ask for a connection. I welcome all folks in the cannabis industry and in fact in any industry to connect with me. So reach out to me and let's connect. The last thing that I would like to leave you with is I know we are all incredibly excited about the cannabis industry that is coming here very soon in New York, particularly the industry where we're able to grow and sell and just have a real business like every other industry has. The one thing that I will say is, frankly, for me, the most important part of what happened with cannabis legalization in this state is that no one is going to get arrested. No one is going to get convicted for cannabis crimes in the state anymore. People that were arrested previously can now get their records expunged. And most important for me, it was absurd what our society has done to its citizens in my lifetime that were convicted due to cannabis laws. People that were convicted had to do what I call check the yes box, meaning if you applied for a job or applied for housing, there was always a question, have you ever been convicted of a crime? And you had to check yes, which meant you obviously had a lesser chance of getting that job or getting that housing. So it's fantastic that the state has implemented that. It is beholden upon all of us, my attorney brethren that are on this call, but for that matter, everyone that is participated today. Educate everyone you know about this. Let people know if you got convicted, you can get it expunged. If you got convicted and in the future you apply for a job or you apply for housing, you don't have to now check the yes box and say you were convicted of a crime. If your employer here in New York State tries to drug test you, with some exceptions, but in most cases, they cannot drug test you for cannabis as part of your pre-employment screening. So it's very important that we educate everyone about these things. For me, that's the most important thing that we're doing. But I'm super excited about this cannabis industry that's coming, and I look forward to working with as many of you as possible that want to participate in it. Thank you for joining me today. It's been great. Like I said, we'll do it again next Wednesday at 4:20, and we'll see you all on LinkedIn. Have a good one.